Good afternoon, everyone. A very warm welcome to this online training. We started the recording so that everybody is aware of that. I suppose our speakers have joined us. Tony, Catherine, and Grainne?
Yes.
Very good. Very warm welcome to the three of you and to all the participants to the online training. It's a pleasure to have you with us. So on behalf of the organizers, I would like to warmly welcome you all and give our many thanks to our special guests, Catherine, Meredith, Grainne Mellon, and Anthony Vaughan for being with us. Special thanks to Anthony for coordinating their team and coming up with the initial idea for this online training. It is a pleasure to hold the first online training in this new project, which is called Smuggling and Trafficking Across the Green Line here in Cyprus. And this first online training, as you can see on the screen, is called Strategic Litigation in the Field of Human Trafficking. It is in the framework of a project which is coordinated by UCLan Cyprus, facilitated by iClaim, with the expert knowledge of Step Up Stop Slavery and the generous support of the British High Commission here in Cyprus. Please be reminded, everyone, that this online training is recorded for the purpose of widening access to educational resources, and that you have been asked to consent to this. I would please ask you to keep your cameras and mics off and to use the chat function in the MS Teams classroom to ask questions or make comments. If you do not wish to appear at all on the recordings, then don't make use of the chat function either. Can I please ask all and remind all that each speaker and other participants to this online training will take part for educational purposes, and it is an educational setting. Accordingly, what each participant will provide verbally, electronically, or otherwise must not be accepted or interpreted as either legal advice or any other form of advice. Subject to the professional background of each of us and each participant, each attendee, participation may contribute to their formal or informal continuing professional development or CPD, personal development, PD, or other self-managed learning and development needs. Cyprus registered lawyers have been asked to provide their registration numbers so that we may report their CPD hours for this webinar onto the CPA platform. It is, however, necessary to attend the whole duration of the webinar to collect the hours. Can I check that everybody can hear me well, because I have a bad network quality icon here. So before I continue, may I ask us to remember the memory of the Honorable Judge Roger Elsie, acting judge of the Senior Judges Court of the sovereign-based areas of Akrotiri and Dekelia, who passed away suddenly a couple of months ago at the launch of this project. This project was close to Roger's heart. He participated to exploratory meetings, as you can see on the picture, and he would have liked us to continue this project. So let us also remember, as he used to, the millions of victims of human trafficking across the world. Thank you, everyone. This online training is organized as part of a multiple approach to the problem under study, smuggling and human trafficking in this instance. The holding of seminars, webinars, roundtables of experts, brainstorming sessions, and online trainings that will inform the other outputs of this project. Other outputs will include a report and a manual. Here in PILA, we believe we are in the right conditions to conduct this mutual learning exercise, which aims at enhancing capacity building across actors, groups, and communities in Cyprus. We are therefore extremely happy and honored to welcome experts and colleagues online from across the divide and across the world who all share a common interest in combating the phenomena of smuggling and human trafficking in this corner of the world. Our contributions as UCLan Cyprus Law School is in the form of expertise and projects with a focus on smuggling and human trafficking across the Green Line, or in Cyprus more generally. This is our second project focusing on the trafficking of human beings in Cyprus. The first one being a mapping exercise undertaken for the British Institute of International Comparative Law on the determinants of anti-trafficking efforts in Cyprus. You can see here on the slide a small description of the said project, which you can find actually on this slide too. So if you go to the British Institute of International Comparative Law's website, you can find the project on the determinants of anti-trafficking efforts, which actually contains multiple case studies, including one on Cyprus from colleagues here at the school. We, in the context of this current project on smuggling and human trafficking across the Green Line, have created a new platform, a demo of which you can see here. And we would kindly ask any participant to this online training today who is interested in publishing anything that would be related to the project to get in touch with us so that we could feature your contributions onto the platform. The platform is made for wider dissemination of expertise and problematics, so we welcome your feedback as well when this platform will be up and running. We are interested in enhancing interdisciplinary capacity to examine, detect and understand the criminal activities of smuggling and human trafficking across the UN-controlled buffer zone and the partition line or Green Line through innovative research methods, and this is why we're here today. We believe this could enhance the sustainability of the island in an intercommunal, national, international setting by increasing awareness as to how lives and interests at stake are endangered by various illegal activities, particularly smuggling of illicit goods, smuggling of persons, and human trafficking. We also hope that we could enhance the ethical literacy and performance effectiveness of anyone working in the field, including NGOs, law enforcement, legal and justice sectors, who engage in the prevention, detection, investigation, and prosecution of criminal activities across the Green Line. We are therefore engaging in active capacity building knowledge transfer that aims at educating and spreading awareness to a variety of individuals ranging from frontline workers to lawmakers, law enforcement agencies and other experts, as well as students, young people and the general public through a two-way transfer of knowledge, and our experts are helping us with this, including today, of course. We believe that this could contribute to further building trust and confidence across the island, which aims at bringing together the two communities in battling long-standing criminality, which instigates tension among communities. There exists a pressing need for stronger collaboration between the two communities on criminal matters. A sincere and effective collaboration on law and order is at a rather embryonic stage in the form of a joint contact room, endangering the obligations of the state under Articles 2, 3, and 4 of the ECHR. So this training series in the field of smuggling and human trafficking rests on two intertwined premises. One is to examine, detect, and understand criminal activities across the Green Line, culminating in the trafficking of human beings. The second is that, in common with other states, the Republic of Cyprus requires a profound change in culture, so that much greater emphasis is placed on both the capacity building and the promotion of awareness of human being as a modern phenomenon. And it is against this backdrop that this specific training on strategic litigation proposes to address a number of questions from a practitioner's perspective. including questions of what are the fundamental considerations in using litigation for societal change, defining objectives and formulating strategy. How can we use international, regional and domestic fora of litigation? What is the importance of evidence and evidence gathering in strategic litigation? And we are very happy to welcome our three eminent practitioners to share their knowledge and expertise in strategic litigation with us today. And in order of appearance in today's online training, we would like to welcome Grainne Meredith. She's a barrister practicing at Doughty Street Chambers in London. She's the head of the anti-trafficking team and is recognized as a leading expert in human rights and anti-trafficking. She was involved in the recent landmark case in Strasbourg of VCL versus UK. Grainne will look at how litigation can be used to achieve outcomes beyond securing justice to the affected individual, which is of course crucial, in a wider strategy for change. Vaughan is a barrister practicing at Doughty Street Chambers 2 in London in public law and human rights. He has been involved in a number of systemic challenges to the lawfulness of UK's processes for handling victims of trafficking and asylum seekers. Anthony will zoom in to look at some of the key international and regional tribunals and institutions which each provide a forum for ventilating individual and systemic complaints. Finally, last but not least, Grainne. She's a barrister practicing at Garden Court Chambers in London. She's also co-vice chair of the Bar Human Rights Committee of England and Wales. She has acted in a number of strategic litigations, including a challenge to the processing of asylum claims within an expedited detained environment. Grainne will move on to address the role of evidence and evidence gathering in litigation, targeting systemic problems, the relationship between evidence and the legal grounds of challenge and common issues that can arise in practice. But before I give them the floor, I just wanted to say a couple of words on the importance of supporting strategic litigation relating to violations of democracy, rule of law, and fundamental rights in Europe and beyond. As you can see on the screen, the European Commission published a feasibility study for financial support for litigating cases relating to such violations back in June 2020. Which highlighted that only a very small number of donors support such litigation, particularly private donors do, and one public funder being the EEA Norway grant system. Another finding of this report is that strategic litigation is embedded in wider projects as one activity, usually, as opposed to identifying individual cases to be brought to the court. So it limits the potential impact of strategic litigation in a way. That means that the assessment of the feasibility of a strategic litigation is done with reference to wider criteria and not at the level of the specific case. Building capacity for strategic litigation in terms of human, technical, and financial resources is fundamental if wider society wants to see social or societal change with respect to issues such as migration, discrimination, or the right to a fair trial that cannot come through public participation only. Hence the importance of the so-called SLAP, to advance fundamental rights jurisprudence, and the importance of doing so before supranational and international tribunals, particularly when you've got a weaker national legal system. Our speakers are pioneers in the field, and we are therefore extremely happy to listen to them now. So I will stop sharing my screen and I will stop talking, and I will invite our first speaker, Grainne Meredith, to take the floor. Thank you very much.
Good afternoon, everybody, and thank you so much for inviting us today. It's really a great privilege to join you all, and really look forward to hearing more about this fantastic project and the work as we go through the afternoon. Can everybody hear me okay so far?
Yes.
Great, thank you. There are a lot of participants today, so I think, given the interest of time, we may proceed. If I can proceed to the talk. Do you want me to wait for a second while the slides come up? Brilliant.
Just give it maybe a couple more seconds.
Sure.
Yeah, it should be all right now.
Brilliant. Thank you so much.
Andrea will be sharing the slides, right? Catherine. So whenever you would like us to change slide, just say so.
Great. Thank you so much. Andrea, if you don't mind turning to the next slide, please, straight away. I'll crack on. Brilliant. Thank you. So I'm going to be speaking today about the building blocks for how we think about bringing challenges in the context of human trafficking, where those challenges might arise, the situations they arise in, the issues that might emerge for challenge, how to pick which challenge to take, how to what changes can be made, what do you want to ask for, what remedies can you seek, what's your aim and what's your target, who is affected, is it an individual or a group, is it a systemic issue, and who is being sued, is it multiple different agencies, is it a trafficker, is it an employer, is it a single government body, and what are the different strategies that can be used either in litigation or beyond. Next slide, please. Oh, Andrea, thank you. So, of course, as Stéphanie has already pointed out and has been researched incredibly thoroughly, there are numerous issues that might arise from criminal activities that take place across the UN-controlled buffer zone, the green zone, including trafficking in human beings, and the creation of conditions of impunity for traffickers. It's essentially a very low risk strategy for traffickers to take when their ultimate aim is to profit from human beings. And it's a deliberate strategy to take whichever is a deliberate business strategy to take whichever is the lowest risk model, which appears to be the case here. And in these conditions, there are numerous challenges that might arise in multiple contexts and situations, wherever victims of trafficking might be encountered, where they might be spotted, at the borders, at the police station, in detention centres, in employment, in various situations, in domestic employment, in construction, in cabarets, in immigration and asylum proceedings, where there are accommodation and support issues, and of course in the context of policing and criminal justice, both in nationally and in cross-border cooperation situations. So all of these contexts are covered by this legal framework of human trafficking, and because of that, and because of those situations on the ground and the legal obligations that arise in the context of trafficking, challenges can be brought. When setting these challenges up and thinking about how to bring them, what failures are we looking at? Those failures might arise from failure to carry out basic duties under national law, but also failures to comply with positive obligations and positive human rights obligations towards victims of trafficking. The failure to comply with specific principles, for example, the failure to protect child victims who enjoy enhanced protection because of their lack of agency and their particular vulnerability, the failure to identify victims of trafficking and support them, which is an absolute, as we know, is an absolutely critical starting point to support victims. If victims are not identified, then it's well established that their rights will be denied. They will often be seen as criminals or as illegal migrants, possibly detained, arrested, prosecuted, removed. So the initial identification is critical as the gateway to support, and therefore that a lot of failures can often be brought on that basis. The failure to put in place a national referral mechanism or an adequate national referral mechanism to identify and support victims and to ensure that their needs are met and they're able to recover and to cooperate with the police and the enforcement, the prosecuting authorities. And of course, the failure to apply the non-punishment and non-discrimination principles. These are all broad themes derived from anti-trafficking, the anti-trafficking human rights framework that can be used to bring challenges. I'm going to move on to that in a moment. Next slide, please. So again, the issues might arise because of the frameworks on a systemic level, where this is not just happening in one individual situation, it's happening to multiple victims. It may happen in different ways. Obviously, cases can often be very fact specific, but there can often be repeat failures that practitioners and those on the ground see time and time again, or where there have been reports by NGOs or by the Commission of the Human Rights or the Special Rapporteur or other bodies where there is a well-known issue or a well-known trend. So there may be systemic issues, repeated failures, or there may be individual aberrant decisions, individual unlawful decisions in individual cases that can be challenged. And it may be that you as practitioners see those individual issues in one or two cases, or you may see them in more. And the challenges that might be brought might include, as we've said, the failure to put in place a comprehensive system to prevent trafficking, to protect victims and punish perpetrators. It's basic systems duties under international trafficking framework. As we've said, the failure to prevent trafficking despite knowledge of well-established patterns and routes where there's been reporting on the issue. Protecting victims through effective measures of detection, identification and support, and so on. And of course, the failure to investigate and prosecute offenders and traffickers. So there can be often failures to investigate, or investigations that take place, but they're too long, or that there are significant shortcomings in the way that the investigation is carried out, that key witnesses are not interviewed, that information is not gathered, and we've seen that a lot in the case law of the court, of the European Court of Human Rights, and the failure to prosecute traffickers, where the number of prosecutions remains very low. That's a problem that many states, including Cyprus, face, and the UK faces. The prosecution rates are very, very low. And of course, the need to ensure effective access to justice and remedies for victims against the traffickers and state bodies, and the need to cooperate in cross-border issues. And there's an important duty, of course, in trafficking, where there's a cross-border element, to ensure that victims are protected and that there is due diligence effectively all the way down the trafficking chain, from the start, the middle and to the very end. And a duty in international trafficking law, because of the very nature of the crime, for states and to cooperate with one another, or bodies to cooperate with one another, and for there to be cooperation between lawyers, civil society and the state, all aimed at the better and more effective protection of victims and the prosecution of offenders. Next slide, please. I'm going to just whiz through the next couple of slides. There are, of course, when bringing challenges, there are a range of different sources of law and policy that can be used either on domestic law or international, regional mechanisms and international mechanisms. So, as we know, there is the protocol to the Organised Crime Convention, in particular the Palermo trafficking protocol, but there's also the migrant smuggling protocol, effectively a criminal initially aimed at combating trafficking as a crime, albeit with a human rights element, and that was taken forward and added to in the Council of Europe Convention on Action Against Trafficking in Human Beings, what we'll call ECAT, which is a specific treaty aimed at the comprehensive protection of victims of trafficking, the prevention of trafficking, and the prosecution of traffickers, and takes a global human rights centric approach to the protection of victims. And of course, there are slavery and child exploitation conventions and a whole range of other conventions. Next slide, please. And of course, under the European Convention on Human Rights, there's Article 4 ECHR, which has been interpreted by the European Court of Human Rights to include trafficking and all of its forms, slavery, forced labour, and there's no need to there's no requirement on an individual to demonstrate which of those it is, but clearly if the facts of the case fall within one of those prohibited areas, then that will engage Article 4, which has been shown in case law where there's a situation of trafficking or exploitation. But of course, other rights under the European Convention on Human Rights may also be engaged, and there's often there's a clear overlap in the case law, which is very well established on Articles 2 and 3, in particular in relation to the investigative duties on the state and the operational duty to protect and to protect against imminent situations of risk or harm. There are two specific provisions on trafficking, or two treaties which specifically deal with trafficking within a wider human rights context, and they are the Convention on the Elimination of All Forms of Discrimination Against Women and the UN Convention on the Rights of the Child. And the UN Convention on the Rights of the Child in particular has very important provisions as the lex specialis for the protection of children, through which any challenge involving a child should always be brought. And there are a whole range of other human rights treaties that we're aware of. I won't go into them for reasons of time, but if you have a case involving a person, a victim of trafficking who has disabilities, then of course you will want to invoke the UN Convention on the Rights of Persons with Disabilities. If you have a case that has an overlapping domestic violence issue, then there's the Istanbul Convention. And of course, then there's EU law as well as international criminal law and international humanitarian law. There may be lots of different legal hooks that you might want to use in a strategic challenge, depending on what the issue is and where you want to take it. Next slide, please. And under the case law of the European Court of Human Rights, as we know, there's what's emerged as a well-developed area of case law on Article 4 ECHR, which protects victims of trafficking. And there are three main duties that I've touched upon already. So just to say that this is, of course, as we know, in international human rights law, regional human rights law systems, this is where these duties are derived from, or these positive obligations. The positive obligation to put in place an appropriate legislative and administrative framework providing real and effective protection of the rights of victims of trafficking. The duty to identify, that's really a fourth duty that I would say, which arises from the duty to protect or the duty to investigate, and that's the duty to promptly and correctly identify potential or actual victims of trafficking, and that triggers those onward duties or those specific duties. For example, under ECAT, the duty to refer to a specialist identification body, the duty to spot trafficking indicators, the duty to ask appropriate questions. Rancev will come on to in a moment. And the duty to investigate situations of potential trafficking. This is about situations where there are indicators, signs of trafficking that are not spotted, which are apparent, but they're not spotted by the authorities. Because in a trafficking case, one is not going to be confronted with a person that says, I've been trafficked, please refer me to the NRM, or please refer me to the police for an investigation. As we know, that is rarely likely to ever happen in practice. Victims clearly, it's well established that there are barriers to disclosure. There are often denials of victim status. A victim may not be aware of their rights. May be traumatized, may be ashamed, may be afraid of reprisals. So the duty on the state is to spot victims of trafficking. And there's also really a duty on any agencies that come into contact with victims to be able to spot those indicators of trafficking. And those indicators, those sufficient indicators of trafficking that raise a credible suspicion of trafficking, i.e. the person is a potential victim, trigger those duties to investigate, the duty also to take operational measures to protect a victim from harm, i.e. the classic Osman duty, and to remove the individual from that situation or risk. Next slide, please. What kind of strategies can be used, and where might those strategies be used? So there are clearly domestic cases where cases just simply happen on the ground, whether that's because a victim of trafficking has been encountered in a police station and you need to, and maybe has been arrested as a potential, as an accused person. Do you need to challenge a potential decision to prosecute them? Is there a victim of trafficking who has not been identified? Do you have to challenge the decision, the failure to investigate? Or what about a situation of a victim of trafficking who is in immigration detention or other custody? Can you apply for bail? So there'll be those situations on the ground that where immediate action needs to be taken, and a case is brought, proceedings are brought very quickly on the ground. Can those be used as a vehicle to raise these wider issues of trafficking, these wider obligations that the state owes towards victims of trafficking? So they might be criminal or they might be civil cases. There might also be strategic challenges that you as lawyers or practitioners think about, where you're seeing those repeated failures and you think, how can we bring this wider challenge and how can we develop it? And there are, of course, there's international litigation if domestic remedies are exhausted or if they're ineffective. There are also parliamentary and media strategies. So, for example, if there are these repeated issues, what mechanisms can you use, or can you use the media to raise a profile of the case or a complaint, either to assist the aims of litigation or to get that litigation off the ground, to create a groundswell of importance around a particular issue. So that might even include making submissions to doing reporting as NGOs, or contributing to shadow reports for the UN treaty bodies, or making submissions to the US State Department Trafficking in Persons, or making reports or complaints to Greta, the group of experts on action against trafficking in human beings, the monitoring body to ECAT, and using media, or making, if in the Human Rights Council, where there are the sessions, making use of that to raise particular issues or raise the profile of cases. Next slide, please. I'm just going to whiz through the next couple of slides. I know Grainne is going to deal with this, but there are going to be different cases. There might be questions about, is a particular issue shown in an individual claimant's case, or can an NGO bring a case with standing that shows that this is affecting a large number of individuals? Next slide, please. Similarly, who's the correct defendant if there are systemic issues? Is it one defendant? Is it a trafficker or an employer in individual or private litigation? Or is it a public sector, public authority? Of course, there are many. Is there one individual perpetrator or tortfeasor, or there are multiple. In the European Court of Human Rights, that does away with that issue because it treats the state as a whole. But in litigation domestically, that's often something to consider. And if there's one, there might be one particular body like the police or the prosecuting authorities, but there may be other bodies that are directly affected by a particular decision. And do you need to involve those? Next slide, please. So as I've just mentioned, there might be cases where an interested party needs to be involved. So think about who might be directly affected by this judgment, or if a judgment is issued. Also, would your case be assisted if there were third-party interveners, NGOs, or the Council of Europe Human Rights Commissioner, Greta, the UN Special Rapporteur on trafficking, and the rules of the court. Of the European Court of Human Rights provide for third-party interveners and the process for that if a case is communicated. And there have been very interesting and effective examples of the use of third-party interventions, including by the Commissioner, by the UN Special Rapporteur and others in the two cases there, VCL and AN, and MSS in Belgium and Greece. Next slide, please. Thank you. I've got two case studies now, Rantsev, and the next one that will follow is on Chowdhury. And I'm just conscious of the time, whether you'd like me to deal with these or whether we can come back to these in discussions. Stephanie?
Yes, Catherine, you still have a good 5 minutes if you would like to go through. All right. This. Thank you very much. It's so interesting. Thank you so much.
Oh, that's great. Thank you. I'm usually running out of time, so that'll be a first. Thank you. So, two case studies that I wanted to look at to try to bring some of the issues that I've been talking about at a rather abstract level, to bring it into a particular case. Are the case of Rantsev on one hand and the case of Chowdhury on the other, that I'll come to in a moment. There are lots of different cases, of course, but I'm just going to pick those two for two particular reasons. Rantsev is a case of an individual applicant, and Chowdhury, there are a group of applicants, and there are two cases which show and highlight some of the points that I've been making. But of course, there are a whole range of other cases. These are two just select examples. So in Rantsev, as we know, this is a case. This is Rantsev against Cyprus and Russia, and in Rantsev, and I'm sure this is a case that you'll all be very, very much aware of. I'm raising it as well because it seems from the report of the British High Commissioner that there may be still some of these themes emerging today. So how can we use that case going forward? So Rantsev, Rantsev was Mr. Rantsev was an applicant father who brought the litigation on behalf of his deceased daughter, and she was a potential victim of trafficking from Russia to Cyprus. Mr. Rantsev was represented by a Russian lawyer, but there were two third-party interventions, the two NGOs, the AIR Centre, Advice on Individual Rights in Europe, and Interrights, who developed some of these wider themes on trafficking, because it was really a groundbreaking case where trafficking hadn't been well developed in the case law of the court under Article 4. And it was brought against, as we know, it was brought against two states, Russia and Cyprus, which is incredibly important in any case in respect of the duty on the state to investigate all parts of the trafficking chain, from recruitment in the country of origin to the country of destination, and the route by which that trafficking occurred. So in this case, as we know, Miss Rantseva was a 20-year-old Russian woman who was recruited by a cabaret owner in Limassol by an artist visa route to work in his cabaret. When she got here, when she got to Cyprus, she was issued with a residence permit, and she started work in that cabaret and stayed in an apartment with other women. A third party, her encounter with the authorities came about because a third party, it were very strange circumstances, but a third party requested effectively that the police arrest Miss Rantsaver, and she was ultimately brought into the police station, and an immigration check was run on her that established her artist visa, and essentially that was all that was asked of her, and she was then released back into the hands of this third party, where, despite there being strong indicators of trafficking in her situation, which were not spotted, which were not investigated, questions were not asked, she was handed over, and hours later she was found dead, again in very suspicious circumstances. There was an inquest, an investigation, and subsequent proceedings in both Cyprus and in Russia. And what the court looked at were the first and foremost reports on the situation of artistes in Cyprus. So this very specific route, where it had been well established in reports of the Ombudsman in 2003 and the Commissioner of Human Rights in 2008, that route was being used for essentially resulting in the trafficking of women in artists in cabarets in Cyprus. Looked at the law on trafficking and some of those instruments that I've mentioned, and then set out general principles and the way in which trafficking is engaged under Article 4. And then found a violation of Article 4 ECHR in relation to Cyprus because of this, on a systems basis, a breach of the system's duty, because the regime of artist visas did not provide effective protection for Miss Rantsaver against the risk of trafficking. And that was based on those two reports that I had mentioned in 2003 and 2008, which had identified the weaknesses in that route, as the court put it, and the risks that those routes gave rise to in relation to trafficking. And then went on to find a breach of the positive obligations to protect Miss Rantsaver from the risks of trafficking, based on the international instruments on Palermo and the Anti-Trafficking Convention, and used those well-established principles effectively that the state knew or ought to have known against the risks of trafficking and failed to protect her. And there were multiple failures that had been found in that case. Next slide, please. I've just got a moment to move on to Chowdhury. Thank you. So Chowdhury was a case of a group of male workers from Bangladesh who were picking strawberries in Greece, and individually or as a cohort they were subjected to trafficking and forced labour, where there was recruitment, transportation, harbouring by means of coercion, fear and force, and that use of force in that case for the purpose of exploitation. And Greta made a third-party intervention in that case. And this is important. Chowdhury is important for a number of reasons. The way that the court developed the principles that had been set out in Rantsev and took them further were particularly important. And there were, in particular, the use of ECAT, the Council of Europe Convention on Action Against Trafficking in Human Beings, which informs the interpretation of Article 4. Furthermore, that the interpretation of ECAT itself by Greta assisted the court in the interpretation of Article 4. So you have this step of ECAT as interpreted by Greta in relation to Article 4 as interpreted by the court. So it's putting a flesh on the bones of ECAT within the human rights context of the ECHR. And really importantly in Chowdhury as well, it debunked several myths in relation to trafficking. So that often authorities see the situation of migration as a migration only issue, whereas Chowdhury established that, of course, migration increases the vulnerability to trafficking, and that that immigration routes are often used in trafficking as a trafficking strategy, as I say, as well as those wider principles. And just to mention as well, another case which is really important in terms of where you see these cases arise is Laulhé and Greece, where you have a victim of trafficking in a detention centre, arrested by the police, was identified but not quickly enough, shortcomings in the investigation by the police, failure to investigate trafficking and the traffickers, which meant that they were not prosecuted or there wasn't an effective investigation. And in that case, an important point was that from the Article 4 perspective, there must be a global approach which is taken to trafficking. So looking at all parts of the trafficking chain and looking at the interrelationship between how the identification and support of a victim on one hand can encourage their victim to come forward and cooperate with the police and with the authorities on the other to prosecute the offenders. And so you need both of those things in conjunction with one another, as well as cooperation, in order to have an effective strategy. So Laulhé and Greece, again, built on principles, particularly in Rantsev, and said you've got to take this global approach to trafficking, which really means having a joined up approach. I'll stop there and very much look forward to any questions that might arise whenever the appropriate time is, or otherwise hand over to the next speakers. Thank you so much.
Thank you so much, Catherine, for that roundup view of the importance of being strategic. And this is thank you so much. It was extremely helpful, I think, for everybody listening to you. Questions will come when we go to the Q&A. Yeah, thank you. Tony, the floor is yours. You've got 25 minutes. Just let us know when you want the slides to move. Thank you.
Fantastic. Well, thanks very much, Stephanie. Thanks a lot, Catherine. Catherine has really comprehensively sketched out the failures or injustices that may give you grounds for complaining that Article 4 or other Convention articles have been violated in an individual case. So what I was going to do is look at 4 key international mechanisms to achieve justice, either for the person concerned, or to investigate, or to address, or even to publicise systemic issues of the wider issues that are underpinning the problems with trafficking, or indeed both, achieving justice and making wider points about the system. So if we could have the next slide, please. In fact, 2 slides forward, because I think the first is about 3 slides forward. There we go. So these are the 4 mechanisms I was going to sketch through. So the first is the ECHR. The second is the European Council of Europe Commissioner to Human Rights, and the third and fourth are the UN Special Rapporteur on Trafficking and complaints to the UN Human Rights Council. So only the ECHR is the only judicial body whose decisions are in the main binding on signatory states. I say in the main because there are some countries like Russia who've passed legislation which means that the rulings aren't binding on them, but I don't think that's the case in Cyprus or indeed for Turkey generally. But the ECHR, as you know, deals primarily with individual complaints, although, as Catherine has been explaining, those individual complaints may encompass wider problems that the court can address through the individual petition. The other 3 are there to investigate wider problems and are less focused, and in some cases you can't even bring an individual petition. But all of them have the potential to play an important role in legal strategy, to bring international attention to the challenges that are posed by human trafficking, and to hopefully start to turn the tide against it. Next slide, please. So I'll start with the ECHR. Now, these are the essential conditions, and I'll really focus on the first two of them, but just to lay it out, the matters that are complained about before the ECHR have to be within the jurisdiction of a contracting state. They have to be petitions brought by victims, which I'll come back to the meaning of that under Article 34 of the Convention. And then there are these other conditions. You have to have exhausted your domestic remedies, and there is the potential to raise claims for compensation. And in cases where there are sustained violations, the court has power to issue pilot judgments. An example being prison conditions in Russia. There are so many decisions from the ECHR that deal with that issue that the ECHR has issued pilot judgments. That obviously presupposes that there are enough cases coming before the court for it to actually see enough of a trend to issue those judgments. Next slide, please. So in terms of our context, Cyprus and the island of Cyprus and trafficking, I think this is important to make a couple of points about jurisdiction. So it's all about, in this context, effective control or authority. And it's established already that Turkey's control over northern Cyprus is such as to found jurisdiction for the purposes of the convention. So you've got the Laulhé case in Turkey in 1995, which is a clear authority. I think somebody needs to plug in the laptop there. A clear authority to say that if you brought a complaint against Turkey for the failures of the Turkish Republic of Northern Cyprus government, that would fall within the jurisdiction of the Strasbourg court. And it is important to note here that in the trafficking context, that state responsibility may extend to effects extending outside the territory, and Rantsev is a good example of that. Next slide, please. So in terms of being a victim, the requirement that a person is a victim before a petition can be brought means that non-governmental organisations will in general be ineligible to do that. Article 34 is the governing provision. Any person, non-governmental organisation or group of individuals claiming to be a victim, but they have to be a victim of the violation. So in the many cases where an NGO is simply having an interest or wanting to change the problem or sort out the problem, that isn't necessarily enough. But it doesn't mean that they can play no role in proceedings which have been brought by a victim, as I shall explain. Next slide, please. So on the domestic remedies point, it is interesting to note that the Northern Cyprus courts have been held to offer domestic remedies which have to be exhausted before a complaint is brought. And the key features of an effective remedy are that it addresses the substance of a complaint. The court can grant appropriate relief, which means the remedy is available, sufficiently certain in theory and practice, and must, most importantly, be effective in practice as well as law. And the court has to look at all of the available remedies that are available. So in our context, the upshot is that even if there are reasons to be sceptical about the effectiveness of whatever available judicial remedies there are, that there'd need to be quite a good reason not to not go down the road of exhausting those remedies before taking a case to Strasbourg. Next slide, please. I think what Catherine was saying covers this. You could see from the Rantsev case that the role of interveners is potentially quite important. And as I say, in a complaint which has properly been brought by an individual, an intervener's role is often quite critical in bringing in evidence about the wider problems, which the court then relies upon in its findings. Next slide, please. So I'm not going to go through the facts of Rantsev because Catherine dealt with that. If we can go to the next slide. One of the things I want, the other things I wanted, sorry, if we go one back again. Yeah, thank you. One of the other points I wanted to make about evidence that comes out of Rancev is that there is a really critical series of reports that was before the Strasbourg court in Rancev from the Council of Europe Commission on Human Rights. So here the commissioner wasn't an intervener like they have been in other cases, but the commissioner had made 2 visits to the Republic of Cyprus in 2003 and 2008. And 3 of the reports were before the Strasbourg court in Rancev. And you can see from this extract that the commissioner saw a tension between, on the one hand, the Republic of Cyprus government passing laws and an action plan to fight trafficking, while on the other hand was issuing these so-called cabaret artiste visas to those who were in reality expected to work as prostitutes. The Commission's view was that the artiste visa made it difficult for coercion and trafficking to be proved and combated, since the supposed purpose of the visa acted as a cover for prostitution. And as you saw when Catherine was explaining the facts of Rancev, she went into the police station, they checked the visa, and then that was all okay. The fact that she had a visa was the beginning and the end of what they were going to investigate. And the Commissioner's evidence was critical to the court's finding that this artiste visa regime led to Cyprus's failure to protect Ms. Rancev. And that material was really, I think, when you look at the number of pages devoted to the European Commissioner for Human Rights' reports, this really was the fundamental evidence underpinning the decision, although there was evidence both from the Air Centre and Interrights, as Catherine said, as well as the Cypriot Ombudsman, who had conducted an investigation into Ms. Rancev's death, and she had reached similar conclusions to the Commissioner, but also in fact pointed out that there had been a lack of training and compliance with the laws that existed in the Republic of Cyprus on trafficking. Just next slide, please. I'll move on to the next slide because Catherine dealt with the findings in that case. But I wanted to move on now to the second mechanism that I was going to look at, the Council of Europe Commissioner for Human Rights as an investigative institution. This slide sets out the formal remit of the Council of Europe Commissioner for Human Rights' function. It's an independent, non-judicial institution, and you can see the 2 main purposes, a number of purposes, but 2 of them which I've set out here. The Commissioner does not investigate individual complaints, so its role of going in and really getting under the bonnet of what is going on is a critical investigatory function which can assist litigation as much as lobbying governments. Next slide, please. So there's some more detail here about the nature of its work according to its formal mandate. So it's visits and dialogue with national authorities and civil society, and it may come up with reports, or a letter may be addressed to the authorities of a country concerned containing an assessment of the human rights situation and making recommendations on how to overcome shortcomings in law and practice. It can also do thematic reporting and advising on human rights, systemic implementation and awareness raising, as it says. Next slide, please. As far as I can see, and I'm quite happy to be corrected here, that the last visit that the Council of Europe Commissioner for Human Rights conducted to Northern Cyprus was in 2003, and that was part of a visit to the Republic of Cyprus. So it was really a sort of an extra part of that visit. It wasn't the main focus of it, which is understandable given the status of Northern Cyprus. But you can see from this extract that the Commissioner spoke with politicians, civil society, lawyers, journalists, detainees, and others. So it was a really comprehensive visit, but didn't consider the issue of trafficking in that territory and didn't make any recommendations. But this shows that notwithstanding that it's the Republic of Cyprus, which is the European Union, that wasn't a reason to stay away from Northern Cyprus. And that's important to note in terms of the scope of any potential reporting or investigatory work that the Human Rights Commissioner may in the future be called on to conduct. Next slide, please. The next mechanism I wanted just to touch on briefly is the Special Rapporteur on Trafficking. This was an office that was established in 2004 by the UN Commission on Human Rights, and the Special Rapporteur is one of the special procedures of the UN Human Rights Committee, UN Human Rights Council, and is one of several independent experts to report and advise upon human rights issues from a thematic or country perspective. So it conducts communications, country visits, annual reports, but it's clear that by virtue of the office of the UN Special Rapporteur on Trafficking, that it's the reports that are generated by it are likely to be accorded a high degree of respect by any court that is looking into individual complaints. And that is why perhaps a investigation or visit by the Special Rapporteur is likely to be the best possible evidence of trafficking issues in the north and the south, and is something which requires some further exploration into. But if we can go to the next slide, please. There's a bit more detail here about the legal basis for the Special Rapporteur's functions. And communications are a formal step that is taken by the Special Rapporteur and is a communication between the Rapporteur and national governments. They are only made where the Special Rapporteur has received what is said to be reliable information on possible human rights violations. It's usually the case that these communications go through diplomatic channels. And the fact that any individual territory is not recognised by any group or number of nations is no bar to the Special Rapporteur operating. Next slide, please. So the purpose of communications is clarificatory. There essentially is a power to ask for further information, to clarify whether certain steps have been in accordance with people's human rights. But it is very much in the Special Rapporteur's discretion whether to take any such steps. You may not know, but the Office of the Special Rapporteur is not particularly well funded outside of the Special Rapporteur's own immediate expenses. And so you have an individual's office who doesn't properly have a budget to undertake investigations or other steps. And so there is very much a real issue about prioritisation. And you can see also at the second bullet point that it will depend on the credibility and reliability of the information that essentially prompts the Special Rapporteur to take action. So, were it to be the case that anybody was asking the Special Rapporteur to investigate matters on the island of Cyprus, there would need to be a credible package of material and evidence which would make good the problems that had been set out to justify the Special Rapporteur taking steps such as an investigation. There isn't a requirement to exhaust domestic remedies. So again, it comes back to really discretion and the cogency of the evidence that is forming the basis for a request for the Special Rapporteur to act. Next slide, please. So the form of communications, we have urgent appeals, letters of allegation and public and press statements. An example of an urgent appeal or a letter of allegation is where countries are going through legislative change and the Special Rapporteur takes it on herself to essentially lobby the national government concerned. So, for example, in March 2020, the Special Rapporteur sent formal communications to Italy to essentially lobby the Italian government in favour of extending its anti-trafficking rules. Italy had implemented a number of trafficking projects which were due to expire when the national authorities were considering what to do about the extension. And the Special Rapporteur's letter stressed the importance of the Italian authorities approving this extension, and made observations about gaps in the protection mechanisms in Italy, and requested that they be addressed. And her request essentially sought further information, as well as an update on the outcome of the meetings and the extension of the measures. Another example of where the Special Rapporteur has sent communications was where, with a number of other rapporteurs as well, in fact, when there was a letter to Malta and other governments arising from Malta's decision to close its ports as a measure to address COVID-19. Now, a boat had travelled from Libya containing refugees and migrants, including women and children, and it had sunk, leading to the death of 5 people. And the letter requested an explanation from Malta about various matters, including why the closure of the Maltese ports, or how the closure of the ports was consistent with international human rights norms. It asked for information about search and rescue operations and how they were to continue operating, to explain how distress calls were being handled, an explanation as to how the boat in distress was not rescued. So quite specific requests and quite comprehensive requests, together with other special rapporteurs, to put the pressure on Malta to provide information and be accountable. So that's an example of how those communication powers can be used. Again, either if it's not completely obvious on the face of media reporting, obviously requiring a sufficient amount of evidence to trigger those steps. And I should say the Special Rapporteur, in fact, recently gave evidence to the UK Parliament in relation to our Nationality and Borders Bill, which is our government's proposals to crack down, if I can put it that way, on the way that trafficking victims are treated. Next slide, please. So, country visits are another way of the Special Rapporteur bringing to bear her expertise. They are, however, by invitation, but there are ways in which the Special Rapporteur can solicit an invitation by communicating with the government concerned, by discussions with the diplomats. So there is a way, if she's sufficiently worried, or he, depending on who it is, about the situation in the country concerned, there are ways and means to try to get a visit. But again, very much dependent on the Special Rapporteur's capacity and priorities. And again, previous reports into the state of human rights or trafficking in relation to specific countries have been comprehensive and, where necessary, appropriately critical of the circumstances. And again, this type of evidence is likely to be given a lot of weight by a court. Next slide, please. So the last two, just looking at those very briefly, last two mechanisms, a complaint to the UN Human Rights Council is one of them. And these are investigations into human rights issues occurring anywhere in the world under any circumstances. So again, not limited to countries which are recognised by certain blocs or other countries or the United Nations. We're talking about substance of where violations are occurring. Importantly, the procedure can ensure the confidentiality of victims against member states, although there is a requirement to exhaust domestic remedies, and you can't use it where the Special Rapporteur is already on the case. But confidentiality may well be something that is particularly relevant in the context of Northern Cyprus. Next slide, please. And then the last mechanism I was just going to touch on is complaints to the Human Rights Committee. And these are, unlike the previous mechanism, individual complaints mechanisms. So it's seeking rulings from the committee as a quasi-judicial body, in the same way as they are lodged in the Strasbourg court, although the rulings of the UN Human Rights Committee are not binding in the same way as Strasbourg rulings are. And communications can be made in respect of any alleged violation of the International Covenant on Civil and Political Rights in an individual case. So these are different mechanisms which have the potential to prompt national governments into action, either by binding legal rulings or via hard-hitting reports, which themselves create pressure for change. But even in the case of mechanisms and decisions from mechanisms which are not binding, the international impact and, if necessary, the embarrassment that is caused by rulings of this nature, I don't think can be underestimated in formulating any strategies for dealing with problems of trafficking. And so with the right evidence, with the right forum, with the right set of facts, and these are mechanisms which could be of real help in any strategy to address trafficking here. But I'll call it a day there. But obviously invite questions and discussion at the time we do that at the end, because really that's where the real value in these seminars is, I find, in really finding out about what your experiences are in dealing with these issues. So we look forward to that at the end.
Thank you so much. Tony. This is extremely interesting, and I'm so grateful that you and your colleagues, Catherine, Tony, yourself, and Grainne, I'm sure you have taken the time and made the effort to actually relate to what's happening here. So this is so helpful for us. I can think of a couple of questions that are going to come up because we've previously discussed them when you talk about, particularly about hard-hitting reports. And I think you have identified some of the shortcomings of those, reports and the possibility of supranational strategic litigation when it comes to Cyprus. But we keep this for the Q&A because I'm quite sure that this is an interesting part of what we do. Now it's time for Grainne. Hello, nice to meet you. And Grainne Mellon, I did not give your surname when I presented you earlier. So now I'm fixing this. We're very happy to have you as well. The floor is yours for 25 minutes. Thank you so much.
Thank you very much, Stephanie. And just to reiterate, a big thanks to all of you for joining us. And I agree with what Tony said, that the part we're most looking forward to, I think, is the discussion to talk to all of you as colleagues about the issues that you're facing and your current cases and so on. So I'm going to try to be brief so that we all make sure we have enough time for the discussion. But I am going to address some of the more practical issues about strategic litigation. And to do that, I'm going to talk about, in particular, some of the cases in the UK, because that's what I know, and some of the ones which have been successful and unsuccessful. And in particular, to talk about how to frame a challenge in the trafficking field, and in particular, how to gather evidence. Next slide, please. So I'm going to try to cover the role of evidence and the importance of evidence gathering in litigation targeting systemic problems, the relationship between evidence and the legal grounds of challenge, and, as I've said, some common issues in practice. So that includes what type of claimant, and Catherine touched on some of this in her presentation, different options for strategic litigation, domestic litigation, strategic litigation, the different types, and in particular, potential sources of evidence, just so that we start thinking about the ways in which we can prove and hopefully win some of these cases. Next slide, please. So before we get to the issue of evidence gathering, we obviously always need to think about some preliminary points about how we frame any challenge in this field. And this then determines how we approach the issue of evidence gathering. So who is your client going to be in any one of the cases that you might be thinking of bringing? There are obviously a couple of options. One is an individual claimant. The other is a number of individual claimants whose case raises common issues or themes. And another option may be an NGO working in the field, so to bring a claim on their behalf. Next slide, please. So there will be a number of factors to think about in choosing which claimant may be beneficial or best for the issue in your case. If you're representing an individual client, one thing which we'll always need to remember about is the extent to which any strategic objectives conflict with your client's individual interests. For example, you might want to get a landmark judgment that changes the law in a particular area, but sometimes it will be in your client's interest to reach a settlement or pursue an alternative remedy. And that always has to be borne in mind at an early stage. And of course, that can be compounded if you are representing a number of clients, because they all may have different interests, or they may have different facts. And also, if you're representing an NGO, you will obviously have to remember, and Tony touched on this, that there has to be standing. And I don't know what the position is in the jurisdictions we're talking about, but certainly in Strasbourg, as Tony said, it can be difficult for NGOs to bring a claim. They often have to participate in another way, including by way of amicus briefs or interventions or evidence filed on behalf of individuals. So it will be important to begin with to check all those rules in whatever forum you're bringing your case in, and to see which claimant is best in any individual case. Next slide, please. So I wanted to give some examples of different types of strategic litigation in the UK, all of which have taken a slightly different slant in terms of who is actually bringing the claim, and some of which have been more successful than others. But as I've said, sometimes strategic litigation doesn't need a large number of claimants. It can be brought by one or two individual persons, but it can still achieve real change and real tangible benefits for a larger group. And one case that I thought of in England, which I think is a good example of this, is a case called TDT, and I've put the link in my slides, so if anyone is keen, they can read any one of these 4 cases after the presentation. But TDT was a case of a trafficking victim who was released from detention without any safety mechanisms being put in place, and was subsequently re-trafficked. And in that case, the English Court of Appeal found that there had been a breach of the Article 4 operational duty that both Catherine and Tony touched on in Ransev, and gave lots of guidance on the thresholds of credible suspicion and real and immediate risk, and how that should be applied in practice. So the guidance given in that case has affected many other victims of trafficking, as well, of course, as the young man in this case. So he was just a single claimant, and it was just about his facts. It wasn't a systemic challenge as such, but we can see how it really achieved an important strategic objective in reinforcing the UK's Article 4 obligations in these types of scenarios. Another good example is from Strasbourg, and again, we've talked about it. This is the recent case of VCL against the UK. And this was a case involving 2 claimants, 2 trafficking victims who were convicted of criminal offences that related to their trafficking. And both of them, they were convicted, and both tried to appeal their criminal convictions in the Court of Appeal and didn't succeed. But they did succeed in Strasbourg in establishing breaches of Article 4. And the court made lots of criticisms of the UK's approach to prosecuting victims of trafficking, and held that the UK had failed in its operational duty, and Catherine was involved in this case. And so, again, brought by just 2 people on their individual facts, but a very important strategic objective, which will impact on the legal requirements for all state parties to the convention. Just quickly, a case that was successful, brought by an NGO in England, where it is possible to bring, where NGOs are, it's easier to have standing than in Strasbourg. It is the detention action case, where it was successfully argued that the procedure for processing asylum claims was grossly unfair. They were rushed through in an expedited procedure. They had very little time, crucially, to prepare or gather evidence. Victims of trafficking, victims of torture had limited opportunity to be removed from the process. And this was a challenge under domestic law, and luckily it succeeded. So a positive example, and I'm keen to hear what your experiences of bringing claims on behalf of NGOs is in either Northern or the Republic of Cyprus. And then finally, I'll come back to this case later, but Tony and I were involved in the case of Hussein, which was brought by a larger number of individual claimants, again to the process of expediting asylum claims in the UK. This was brought on behalf of 4 individual claimants, but there were, I think by the end, over 100 other claims stayed behind it. So 4 different types of strategic litigation, all of which will have different evidence requirements, as we'll come on to see. But just when we're thinking about bringing cases, it's always useful to think of the different options and what that means practically and the implications for that, both for us as lawyers and also for our clients. So with that in mind, let's turn to the issue of evidence gathering in some of these scenarios. Next slide, please. So this is a very obvious point for all of us as lawyers, and we'll all know it well. But before we look to evidence, we of course have to remind ourselves of what exactly it is we're seeking to establish. So this is the point about how evidence interacts with the legal grounds of challenge. So obviously, as we do in every case, think about what conclusion we want the court to reach, what are the different legal routes to achieve that, and then what do we actually need to prove to reach that conclusion. And then, of course, that will guide what evidence that we need. So, for example, as I've said here, Catherine's taken us through in lots of detail the Article 4 operational duty. So just by way of a practical example of showing the relationship between evidence and the legal grounds, if you have a number of clients who, for example, weren't protected against the risk of re-trafficking by the state, and you want to argue a breach of the Article 4 operational duty, the tests that you would need to show and the evidence you would need to show to succeed in establishing this test, you need to look, as I've said on the slide, of what the authorities were aware or ought to have been aware of, for example, and both of those bullet points will need to be proved in any individual case. Next slide, please. So potential sources of evidence, and we've touched on this already, and I think Tony's point about RANSEV is a really good one, which we'll come back to, but there's lots of different types of evidence, and this applies, of course, to all litigation, but I think particularly to trafficking, there can really be a wide range of evidence adduced, and actually there's a degree of flexibility in proving your case, which I think can be really beneficial. So the first one is obviously any documents held by the state themselves, interview notes, file notes, decision letters, and crucially, this will mean at an early stage thinking about disclosure, so whether in the litigation or through GDPR, where applicable, subject access requests. So state evidence can often prove your case, particularly where there are very obvious failures. Secondly, will be witness statements from your own clients in the normal way, whether they're individual or multiple claimants. Evidence from third-party professionals who have worked with your clients, such as doctors, trafficking experts, country experts, or where there's a particular expertise relating to a particular geographical area. And as Catherine has said, general trends, if there's evidence of people from a particular nationality being trafficked into a particular industry. We had this in RANSEV with the type of visa that was in question. And in the UK, a very good example of this is the Vietnamese community being trafficked into nail bars or into cannabis farms. So all of that general kind of statistical country information can all and should all be submitted in these types of claims. And witness evidence, as I've said, from those in the field. And I think that there may be another bullet point which perhaps isn't coming up unless I've made a mistake on my slide, which is international evidence. So evidence from any of the international forums that Tony's taken you through is really important. And I think it's right that in RANSEV, the input of the Commissioner for Human Rights made a big difference, and independent international evidence is given, I think, a particular weight. So using those mechanisms to carry out research or make findings is a really, really beneficial way in any one of the types of strategic litigation that you might bring. And also just to say, evidence from interveners, even if your case isn't being brought by an NGO, think about the role that NGOs can play, and also from international bodies. And I know Catherine mentioned some interventions in 2 cases from the UN Special Rapporteur. She also made a really helpful intervention in a current case against France of HF and AD, an amicus brief about children coming to Syria, from Syria to France, which is currently pending before Strasbourg. I think we're seeing that getting more common, and there's no reason why that can't happen in domestic proceedings as well. And just quickly on evidence, while I remember, it is, depending on the sensitivities of your case, the need for anonymous evidence will obviously have to be thought about. Victims and witnesses, as we know in these cases, can be very vulnerable and vulnerable to intimidation. So I'll be interested to hear what means there are in both the Republic of Cyprus and the North to support victims and witnesses in these cases. Domestically, you can certainly look at things like reporting restrictions, special measures, having an in-camera hearing if it comes to it, or anonymity orders. And of course, evidence can also be adduced by third parties, so journalists, doctors, NGO workers, and that can be anonymous, although I think it can affect in some circumstances the weight to be placed on that evidence. Next slide, please. So far, so good. We have laid the foundation for winning any one of the types of cases that we could bring. But because this is strategic litigation, we obviously have to not just win an individual case, but show in some cases that it's part of a broader systemic or structural failing. And how do we do that? So again, it's really important to think about what we're trying to achieve, and there are a number of things that we could be trying to achieve in hypothetical Article 4 litigation. I've set out any one of the 3 possibilities. Catherine touched on these as the types of grounds of challenge. Just one moment, sorry. So in wider strategic cases, there are some additional factors, and I just wanted to flag those very quickly. So whether the findings in an individual case will be enough, whether you need evidence from a wider range of sources, which I think arguably you do if you're bringing a very systemic challenge. But of course, the importance of remembering not to lose sight of your client's individual facts in any given case. Next slide, please. Oh, sorry, back one slide. Thank you. So I wanted just to finish with the points about in systemic cases, the evidence needed in particular, and we've touched on some of it, but I wanted to mention and give an example of the case of Hussein, which I mentioned. It was the 4th example on the slide that I touched on, the 4 cases from the UK that Tony and I were involved with. And that was a very big case in that, as I mentioned, there were over 100 cases stayed behind ours. And I just wanted to give a flavour practically of the evidence we relied on in that case. And it's all set out in the judgment, but we first of all had witness statements from the solicitors representing the claimants and the majority of the claimants in the stayed claims. We had medical evidence from 2 doctors working with 2 NGOs, in particular in the detained asylum process. So one from Freedom from Torture, one from an organisation called Medical Justice. We had some expert evidence. We had witness statements from our clients, obviously. We had contributions from specialist migrant groups, for example, the UK Lesbian and Gay Immigration Group, etc. So the flavour of the evidence was wide-ranging, and really quite a wide range of data and country information can be adduced through those third-party sources, and that applies to any one of the 4 types of litigation that we've discussed, and in particular to a case like Hussein or a wider systemic challenge. Just to think very broadly about the types of evidence, think about whether there needs to be any anonymous evidence, and always in any of these cases, obviously try to remember not to lose sight of your client's individual facts, which is often the tension or the challenge in these types of cases between what your client may need and the wider systemic point. So I think that concludes my presentation, and luckily in good time for some discussion. So I'll look forward to those, and thank you very much.
Thank you so much, Grainne, for keeping to the time and enlightening us with, extremely helpful and useful information and, well, your expertise in terms of evidence. So this is probably one of the areas where it's probably lacking here in Cyprus, and this is why we're here, actually, to try to help, practitioners and representatives of NGOs and CSOs to be able to perhaps fill in this gap. So thank you so much, all three of you. Now, the floor is open for discussion. We will be using the chat unless someone would like to take the floor. There is one question already from a colleague of ours who happened to be in a very noisy place. So he said he can't really take the floor, take the mic, but he put the question in the chat. And I would read it out for the purpose of the recording, but you can read it yourself. So I guess the question goes to all three of you. I begin by thanking the organizers, speakers, and all involved in this excellent webinar. So this is from our colleague Klearchos Kyriakidis. I would like to ask a question for the Q&A. The Republic of Cyprus has inherited a very British tradition of occasionally instigating an independent judge-led or lawyer-led public inquiry following the exposure of any serious scandal, catastrophe, problem, or other phenomenon with harmful consequences, but seemingly systemic causes. We can give you a few examples later. With that in mind, to what extent could the mechanism of an independent public inquiry help to identify, unearth, or otherwise address the systemic causes of human trafficking across the sovereign territory of the Republic of Cyprus, including the UN-controlled buffer zone? Put in another way, what can the Republic of Cyprus learn from the British experience of public inquiries? And in asking this question, I appreciate that an inquiry cannot fulfill the function of any court. This is from Klearchos. Would you want to say something, or do you want me to give you examples of public inquiries that happen here in Cyprus?
It would be good to know some examples of what has happened as some context.
Yes, so we have had in the past 10 to 15 years some very high profile and very publicized public inquiries. Particularly, we had a lawyer-led public inquiry after the explosion in Mari. I suppose you're aware of that explosion in 2011 that ripped off quite a large part of the island. There were casualties, and we basically remained without electricity in a large part of Cyprus for quite some time. So it was a huge explosion. It originated in some containers that actually had been stocked and left to their own well-being off a military basis, a naval basis. And due to high temperatures and the contents of the containers, which was obviously very dangerous, it exploded. So it reminds us, of course, of what happened in Lebanon quite a lot. It wasn't the same type of toxic materials in there, but it was quite similar. And these were containers that had been confiscated from Syria, basically, so they could not reach Syria. So that is the first type of inquiry that we had, that was lawyer-led, and it was a criminal inquiry. Then we had lately two public inquiries in the form of a commission of inquiry, again appointed by the Attorney General of the Republic of Cyprus. One was on the collapse of the cooperative bank system in Cyprus following the financial crisis. So the collapse was in 2019 that it was actually investigated. So the cooperative bank system in Cyprus, so not the commercial bank system, but the cooperative one. And the third inquiry that we had recently had to do with the so-called golden passports. If you know what golden passports are. So nothing to do with human trafficking, or nothing to do with migration issues, or at least not with migration refugee issues, because golden passports are migration issues, but they are migration by investment issues. So they are very different species. And well, in all cases, very thorough reports were produced by those either lawyer-led or judge-led commissions of inquiry. They were handed over to the Attorney General of the Republic, of course, in his capacity as the public prosecutor of the Republic of Cyprus and as the Attorney General of the Republic of Cyprus, who is also advising the government. And well, not much has happened since then. I suspect that, you know, some of the commissions of inquiry are still under investigation anyway, some of the findings of the commissions of inquiry. So it is a very important tool for small Cyprus, for the Republic of Cyprus at least. It is, but it's a tool that perhaps has its limits in the functioning of the justice system more generally on the island of Cyprus and in the Republic of Cyprus. And it obviously has the shortcoming that was also identified by yourselves in what you presented today, which is that it doesn't really touch the green line. It doesn't really touch the criminal origins of many other problems across the green line, right? So this is not something that is easy to tackle or easy to even approach or comprehend. So I'm not sure whether you will be able to give some sort of answer to Claire, but please, if you can share with us any thoughts, thank you.
Shall I go first? I mean, I don't think a public inquiry could ever be a substitute for an external actor at an international level conducting a searching investigation of their own, because they're just, by virtue of being independent, they're going to have a different approach. I mean, any public inquiry is going to be limited by the fact that there will be internal pressures which militate in favour of maintaining the status quo. And so the identity of the inquiry chair is most of the issue, because if you have an inquiry chair who is seen as establishment and who is going to be sceptical of more searching criticisms of the state, then that is not an inquiry that is likely to take things very far. I mean, although I wasn't involved in it, there's been a long-running issue in this country about what happened at a football match in Liverpool and Hillsborough, in the 80s, I think, where a lot of people died, and there was an initial inquiry by Lord Taylor, who was a judge, who issued findings that were essentially the police, sort of failed to control the crowd, and that's why people died. And over the years, and there was some blame on fans, and there are all sorts of problems with the way that inquiry was conducted. And as I say, with the big caveat that I haven't been involved in it and I don't know all the details of it, but over the years, families were fighting and fighting and fighting for the real truth to come out. And there was a recent inquiry that was established again, which led to much more searching findings and leading to prosecutions of some of the police officers involved. And that's an example of how it took families years and years and years and years of pressing the state at massive personal cost to really show what the truth is. And so I suppose my response is, it depends what the chair is, and ultimately it will tend to be inferior to any outside investigation by virtue of that outside investigation being independent.
Thank you, Tony. Catherine, you had your hand up.
Is that okay? Yeah, just to add to that, I'm interested to know from you as well, from my perspective, obviously, you know, an inquiry can be helpful if it's difficult to obtain evidence, or that's a situation where, you know, as Tony said, there are a number of claimants, or there might be historic issues, and it's difficult to get a case off the ground. And so you're looking for really recommendations, for findings and recommendations that can lead on to some sort of litigation.
Yes.
Whereas totally stand to be corrected, but from what I have seen, there are really strong reports, recent reports in relation to Cyprus, which do touch upon the Turkish Republic, such as there's a report of Greta 2020 and the recent 2021 US State Department report on Cyprus, which then goes on to deal with what it calls Turkish Cyprus. And those reports, you know, Cyprus has accepted all the major rights of individual petition, as far as I can see. It has, you know, the Greta, that there's Rantsev, then there's Greta in 2020 saying that, and the US State Department saying that there have been steps, there have been some legislative changes, but nevertheless making really strong recommendations, particularly in relation to identification, and things appear, reading the 2020 report of Greta and the 2021 US State Department report, which led to a downgrading of Cyprus to tier 2, that trafficking efforts, in particular, the number of identified victims and the number of prosecutions has decreased. There was no prosecution. So it appears to be there are strong recommendations. There's a problem about implementation, and therefore, and potentially about victims. So if there are lawyers and NGOs out there, it would seem to me really ripe conditions where you've got strong reports, strong recommendations, all of the rights of individual petition to use. The numbers of victims on the ground that are being identified appears to be low, but the problem is big. So there's a discrepancy. And this is why, I mean, I stand to be corrected, but just looking from the outside, there seems to be a discrepancy in the issue, the problem on one hand, and the number of victims on the other. And that screams out lack of implementation. So the perfect conditions to bring challenges. So as lawyers, we do this, don't we? And NGOs, we're spotting the victims and saying there has been a failure to identify, a failure, because once you have that, your failure to spot indicators of trafficking, you say they're not a victim. You've treated them as an illegal migrant or a criminal, you, the state authorities. We, on the other hand, have spotted all of these indicators that had you taken the steps to identify them, had you asked the correct questions, had you provided the conditions for disclosure, you would have spotted them. And that leads to that you knew or ought to have known because of the problem, the evidence, those recommendations and the evidence in the public domain. So yeah, from the outside, it seems to me that you've got the recommendations. How can you as lawyers, or we as lawyers, use them to bring cases? I don't know if that's a valid observation or not.
Yes, this is excellent. This is extremely helpful, and this is something that we have discussed before. But let's see if Grainne has something to add.
Thank you very much. I mean, I would be inclined to agree with that it seems an immediate step can be litigation. I mean, one of the problems with getting an inquiry will be the delay, the terms of reference, the appointment of the chair. Whereas I think, as Catherine said, there are some steps which can be taken straight away to try to make a difference. So I think I would support that. I'm not aware, unless I'm unless I'm not remembering properly, that this has been an approach followed in the UK on trafficking. Generally, there haven't been public inquiries on these issues. There is currently the Brooke House inquiry, which is about immigration detention, which I'm not involved in it, but touch on some issues of trafficking, but isn't a trafficking inquiry. So I don't think this has been the approach in the UK. It has been more litigation focused, and that would seem to be the quickest and possibly potentially more effective, at least with more guarantees than in our experience an inquiry will give.
Thank you. Yes, that's quite right. Thank you so much. This is helpful. Yes, I think you identified the shortcomings of going through commissions of inquiry, even if they are independent. You basically, I mean, I have to disclose that I participated to the 2 latest commissions of inquiry, and the main issue was the collection of evidence, as you identified. But then, of course, the remit of the mandate was such that, you know, it was recommendations, of course, that were given to then the Attorney Generals of the Republic. But we touched upon something through the discussion that was highlighted as being one of the problems that we need to try to help or enhance at the launch event that we had last month. Now, I was hoping that our colleague, our Turkish Cypriot colleague who is doing a PhD in those issues would be with us now. She's not. But basically what she was reporting, and it's very close to what Catherine was saying, is that yes, you're right that the US system is catching the different jurisdictions of the Republic of Cyprus, but usually international reporting is not catching the different jurisdictions. In other words, the de jure jurisdiction of the Republic of Cyprus, of course, is under a lot of scrutiny. This is very clear. But the de facto jurisdiction of the Republic of Cyprus, so basically it is the areas of the Republic of Cyprus on which the government cannot exercise effective control due to the partition line, there we don't have enough data and we don't have enough evidence. And this was highlighted by our colleague, our Turkish Cypriot colleague, who works on human trafficking across the dividing line. She did quote the US report as being an exception. So there where international reporting, as Tony said, cannot always be used as a hard-hitting instrument because it's not caught by it. Strategic litigation is something of much interest, but it may be something that is actually difficult to put in place because you come up with issues that are maybe unique to Cyprus, which are issues of recognition of international recognition of authorities, of occupied territories, and it's extremely difficult then to, at least for the formal litigation, to think or to decide to whom you're going to go, against whom you're going to go. Obviously, Tony referred to the Laulhé case. I mean, it's quite clear that the basis could be there, but there are extra steps in Cyprus because of the division of the islands, and this is problematic. However, I thought that what Tony referred to as being the other approaches, so the softer approaches using Council of Europe and UN basically bodies, that is definitely something that we are ready for. And Catherine is very right. There is absence of evidence shows that there is a problem, including in the Republic of Cyprus. And you're right about that we are probably ready. And when we say we, it's the lawyers, but also the civil society organizations and academics to produce, reports that would highlight the absence or the failure to deal with human trafficking in Cyprus as a whole. So what you have done today for us is extremely useful in that sense, because you have provided us with a guide of all the options available of many of the issues that we need to have in mind when considering strategic litigation, including issues of evidence that are crucial, and that lawyers could hopefully use to think about strategic litigation, but also, you know, the wider legal profession, including academics and NGOs involved. So I do think it's extremely, you know, powerful, and the message is clearly coming across very, you know, it's very clear as you have presented it, the three of you. So we can only thank you for this. I'm wondering if anyone has any other question. I see nothing in the chat, and I don't see anyone asking to take the floor or anything. So could I ask the three of you to perhaps come up with, you know, some final thoughts, maybe, if you have learned anything from the little feedback that I gave you or that Claire Post gave you. In whatever order.
I always think in this scenario, it's we have to just be creative and collaborative and optimistic, because there are often so many different challenges, so many different potential routes, issues. It can sometimes be overwhelming. And sometimes a case is just going to crop up, and you, the lawyer, you, the law centre, you encounter a case and it has all the host of issues, or it has one or two, and you run with it. And we can't control that, but it's good to be looking out for that. So, and we, as you know, all of us in this virtual community, we're human rights lawyers, which means that we have to be optimistic, and jigsaw, put these pieces of the jigsaw together. So I just very much look forward to maybe having more conversations, or seeing the work that you decide to go and run with in the future. That's my takeaway for myself.
Thank you very much, Catherine.
And good luck.
Yeah, I just want to echo, I think, what Catherine said. I seem to have turned off my video while saying that, which is that it's always lovely to talk to fellow lawyers. I think we were struck by the difficult circumstances that you're working in and the really difficult, wide-ranging issues. And I just wanted to note that and congratulate you on all of your hard work. I think it would be brilliant to meet in person, because the conversations are always more creative and a bit more collaborative. It is hard in an online forum, not least when you get knocked on the door, for which I apologize again. But I just wanted to say that hopefully we've given some food for thought, and it's certainly very interesting for us to think about the situation that you're all in, and whatever support we can offer, I think we'd be very happy to do so.
Thank you so much, Grainne. I mean, I have lots of other questions as a follow-up, but not for this webinar. Definitely, you're right, it would be great to meet in person. Tony?
I definitely echo everything that Catherine and Grainne have said. I mean, there's no substitute for sitting across the table and actually talking about these issues, because we could talk about these issues for hours, and there's a lot that we can learn from you. I think that the message that I would really underline is evidence, evidence, evidence. Whenever I'm arguing these types of things in front of judges, or arguments that Article 4 has been violated, or that there's some systemic problem, the judges always say, where is the evidence? Take me to the evidence. And without the evidence, you know, we can be as outraged as we want to be about these things, which we rightly should be. But specific evidence about what is going on, in particular in the north, as Catherine said, there's a load of great reports in terms of the south, but, you know, subject to one or two exceptions, it's all about the north. And that's why I think those mechanisms, particularly the UN Special Rapporteur's investigations, the UN Human Rights Commissioner's report powers, are really, you know, not some further discussion needs to happen about what can prompt those, because once you've got a threshold amount of evidence about what's going on, and you make those, you put the pressure onto those officers to come down and see what's going on, and you get a report, then that's it. You can take your cases, and your cases are entirely justified, and then the individual injustice is simply an illustration of the wider problem which you've established. So I would say evidence at this stage. But agree with everything that everyone else has said, and the importance of collaboration. And we obviously love to come out and discuss it with you when we're allowed to.
Thank you so much. You're perfectly right. And obviously, someone in the chat has, put a comment that you can have a look at, and he points out to the same thing, to the importance of understanding the crime. And this is perhaps what is missing here. And Catherine has nicely commented as well. That yes, of course, more training is needed. And of course, when we do more training, then again, the trainings, it's very difficult to penetrate, the law enforcement agencies, let alone penetrate them across the line. This is just not possible. So we lack collaboration, we lack exchange of information, we lack exchange of good practice if there is any, and we lack building capacity across the green line, because basically the criminals are taking advantage of the green line to be able to expand illicit activities, including eventually human trafficking. So hence the idea of collecting hard evidence, and or the absence of hard evidence perhaps, and then going along the lines of what Tony was saying, which is a longer term plan, but it is a worth the try plan. So it's time to close now, but I wanted to thank you so much for spending time with us, a lot of your time, your very valuable and busy time preparing for today, but also spending it with us, explaining, your experience and relating, because I know that it's not easy to be human rights lawyers and to actually, utilize strategic litigation, and you have lots of very pragmatic considerations around the use of strategic litigation. So I think, the fact that you are examples of living examples of the good side of society, of trying to do something about it. And this is very important, hoping, we can draw lessons from this. So thank you, everyone, very, very much. Andrea has put something in the chat for everybody. If you would like to, please fill in our feedback form so that you can give us feedback on this online training. I would be very tempted to say we would like a follow-up, but we will see. You can see that colleagues, even from the UK, who had joined us, said how helpful that has been. So this is great. And it's good to see that it's appealing not only to lawyers, but also to criminologists and related disciplines to law. So this is really great. In the meantime, let me wish you a very happy and safe festive season, which is what we want everybody to be at the moment, safe. And thank you very much, and see you in the course of 2022.
Thanks for having us.
Thank you very much.
Very welcome. You take care.
Bye-bye.
Bye.
Thank you.
Bye. Bye.